Hello and welcome to this short video on advertising of foods. My name's Andy Bowles and I'm a food lawyer. Now this is the 9th in a series of 100 short videos that I'm recording on UK food law topics, and you may be watching this of course on our online website, our training service. If so, you'll have access to a whole range of other courses and webinars and materials and so forth. But if you're watching this on our YouTube channel, you are of course very welcome. Now, what I'm referring to advertising of foodstuffs, I mean the way that food is promoted in whichever medium. So it could be that the advertising is in printed media, in a newspaper, it could be broadcast on TV or at the cinema or on radio, or it could be through social media or any other form of communication. Advertising is generally considered to be a food standards issue, although the actual specific legal requirements are held within general food law. So it falls neatly between those two categories of food law. But what the law actually requires really is that any advertising of food throughout whatever medium should not mislead the consumer. Now, when we're thinking about misleading the consumer, it's not the fact that someone has been misled, because someone might have misunderstood or misinterpreted a perfectly legal advert. It's not something that one person is affected. We normally consider, when regarding the term misleading, the average consumer. And in food law, we generally think of the average consumer as being reasonably well informed and reasonably circumspect. So we're looking at advertising shouldn't mislead the average consumer. So what are the rules? Well, the rules relating to, for example, a printed advert for a food, actually the detail of the rules will be found in the Food Information for Consumers Regulation. So in other words, this is really food standards law area, but I said the general requirement not to mislead is in general food law. So there's an example behind me of an advert for an instant oatmeal with berries. And there's a number of issues that arise on that printed advert. It refers to organic. Of course, if they are saying in an advert that food is organic, it must meet the legal requirements for organic. Otherwise, that would be misleading. It says it's healthy. Healthy is a generic health claim. If you're going to say something is healthy, then there needs to be a specific health claim related to that claim. So in other words, by saying healthy, it's just general health claim. There is another video talking about health claims. There would also need to be something else. So a specific health claim that's been authorised relating to a component of that food. It also refers to vitamins. Now, the fact that it's referring to vitamins is an inference. It's implying that those vitamins are present in significant quantities. So by saying vitamin C, tick, vitamin A, tick, calcium, which is obviously not vitamin, but it's a mineral, there is an inference there that they are present in significant amounts. Therefore, if vitamin A is not present, or vitamin C is not present in a significant amount, and the definition of a significant amount can be again found within the Food Information for Consumer Regulation, then again that would be misleading. We have a pictorial reference. We can see berries being poured into a bowl with some cereals and what so. If this doesn't contain real fruit, but instead contains flavours, fruit flavours, then that would be misleading. So you get the idea. Even a straightforward printed advert can be misleading, but actually what you are doing is we're applying the standards of Food Information for Consumers Regulation to any claims being made. Now, when it comes to broadcast media, it's the Advertising Standards Authority that actually are the regulatory body. I'm using regulatory body in perhaps the broadest term because they are actually an industry-led organisation. But they comprise two elements. We have the Committee of Advertising Practice, CAP. They set the standards. Now, for advertising of food, what they do is they look at the Food Information for Consumers Regulation and other relevant regulations, and they pick out the requirements and they've put them into a code of practice, the CAP. With the Advertising Standards Authority, what they do is they look at broadcast adverts that are brought to their attention, and they interpret the CAP, the code of practice, to see whether the advertiser has actually complied with it. So we have those two issues. We have the advertising codes set out by CAP, and we have the advertising standards applied by the Advertising Standards Authority. Now, if you go to the Advertising Standards Authority's website, asa.org.uk, then you'll see at the bottom, I don't know if you can see on the screen behind me, perhaps not, it's a little screen, but you can see ASA and CAP separately listed there. I've just listed a page there at random, a relevant code rule. This is actually CAP Rule 15, which relates to food and claims made about food. So if you go to that website and look at it, or if you're on our website, I've got the link, you can go and have a look at a bit more detail, you'll see that in the chapter 15, it sets out the legal requirements for the advertising of food. So what happens if somebody breaches the code of practice? Well, the Advertising Standards Authority, ASA, will actually issue a ruling. So here's a ruling that's been issued quite recently on Innocent Health Limited, trading as Novamins Nutrition. Now again, I'll put the link of that on our website. But if you look at the detail, the complaint is that this particular food supplement claimed in an advert, and I believe it was on social media, that it could alleviate symptoms of stress and anxiety, but also aid sleep. Now, the Advertising Standards Authority looked at the code, and if you look at the code, pretty much at the very top, it has the general prohibition of medicinal claims. A food cannot claim that it can cure, prevent, or treat a disease. In the view of the Advertising Standards Authority, anxiety would fall within a definition of a medical condition, a disease if you like. So therefore it is not possible for, rather it is prohibited for a food to claim that it can cure or prevent anxiety. It looks at the word stress, and in their ruling, you can read it on there, they were saying, well actually stress is a symptom of anxiety. So therefore we're in the same territory there. If you're actually taking something to relieve the symptoms of stress and anxiety, then that won't be a food. That will be a medicine and is dealt with separately. So therefore they felt that the claim that this particular food supplement could relieve the symptoms of stress and anxiety was a breach of law, and therefore breach of the code of practice, and therefore should be removed from social media. It also looked at the claim relating to helping sleep, and there is an authorised claim for vitamin B12, which apparently is present in this product, although not given particular prominence in the advert. And there is, an authorised claim that if you have a significant amount of vitamin B12, then it can actually reduce or contribute towards the reduction of fatigue. But that's not the same as aiding sleep. And in the view of the Advertising Standards Authority, again, you can read the ruling online, they felt that the advertiser was going too far there. They were actually going beyond the authorised claim. So they upheld the complaint that had been made to them that this advert was unlawful, and they basically instructed the organisation to remove the advert, but also they put their ruling out on their own website so everyone can read it. Okay, that's just an example of advertising in food. I hope you'll join me on my other videos which deal with the 99 other food law topics. Thank you for watching.